Hello, everyone. Good morning, good afternoon, or good evening, depending on what time you're watching this all-staff training module. My name is Christina Patzelt. I'm an attorney with Troon Law Firm, and we've created this Title IX Sexual Harassment all-staff training module to help train you on your new reporting obligations under the new Title IX regulations. We're going to talk about a lot of different things today, but focus mostly on what your obligation is to report, who you need to report to, and what it is that you need to know to report. We always have a caution at the beginning of our PowerPoints. These slides reflect general legal standards. It's not specific legal advice, and especially because these are brand new legal regulations, future legal developments may affect these topics. This training also, we want to note, is not intended to satisfy the comprehensive training requirements for people who are going to act as Title IX coordinators, investigators, decision makers, or appeals officers. If you are asked to serve in one of those 4 roles, please ensure that you receive additional comprehensive sexual harassment training on the new regulations. We want to first cover the legal landscape, which will introduce you to the definition of Title IX and what it prohibits, as well as cover some of the recent legal settlements that have occurred for schools who have been sued for violations of Title IX. The settlements are both at the higher ed level and at the K-12 level. In 2018, for those of us who live in Michigan, we're most familiar with this case, there was a $500 million settlement for 332 claimants against Michigan State University that arose out of the Dr. Larry Nassar case. Also in 2018, there was a $670,000 settlement by Ohio University for 2 graduate students who were sexually assaulted by their professor. In the K-12 arena, both of these cases happened in 2019. There was a $190,000 settlement by Palo Alto Unified School District paid out to a student who was sexually assaulted at school. And here in Michigan, a school district paid out $275,000 for a student who was improperly searched during a Title IX investigation. Not only do we want you to understand that there is legal liability for your school and potentially you personally if Title IX is violated, if there's a failure to report or a failure to investigate, but additionally, failure to report or a failure to investigate can create harm or emotional trauma to a child and create an unsafe school environment for them. This is an exact quote from Title IX. It says that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. We've highlighted in red the on the basis of sex because that is the large umbrella of Title IX, that it prohibits sex discrimination. Sexual harassment is a subset of sex discrimination. Title IX has a very broad application. It applies not only to academics and extracurriculars. Most people, when we think about Title IX, think of Title IX athletics issues. For example, ensuring that the boys and girls soccer teams have to have the same amount of funding or the same amount of facilities used. But it applies to all school programs, education, extracurriculars, athletics. It applies on school transportation and in school-sponsored programs that take place at another location, like a prom or a graduation. The new Title IX regulations that were issued on May 6, 2020 and went into effect on August 14, 2020 have some very big changes. As we've noted in red and bold at the top of the slide here, all school staff now have a reporting obligation when it comes to Title IX sexual harassment. There are also significant changes to the investigation process. The parties in a Title IX investigation now have the opportunity to review and inspect evidence and to provide responses to an investigation report. There's a large emphasis in the new regulations on fairness, due process, and constitutional protections for both parties. It's ensuring that both parties have an equal opportunity to present any evidence, any witnesses, any testimony that they think supports their side of the story, to have an advisor as part of the investigation, and to ensure that there is no bias or conflict of interest, and no prejudgment of anything. The new regulations apply to staff allegations, staff to student, student to staff, and student to student sexual harassment. So regardless of who is the complainant and who is the respondent, So who is alleged to have committed the misconduct and who is alleged to have been the victim of the misconduct, it's all going to come under the new regulations in the umbrella of Title IX sexual harassment. Staff serving in the key roles that I mentioned before, as Title IX coordinator, investigator, decision maker, or appeals officer, must be impartial. There is a significant emphasis in the new regulations on impartiality and there being no bias or conflict of interest by anyone who is serving in those roles or serving in the grievance process. There is a 7-year record retention requirement under the new regulations as well. All Title IX records have to be retained for 7 years. So if you are involved in a Title IX investigation process, which is now called a grievance process, and you have notes, or if a student submitted a report of sexual harassment to you in writing, via email, via social media, make sure that you turn that over to the school so that they can ensure that they retain that record for the required amount of time. There's some new terminology in the new regulations that we are going to be using as we work through this presentation. Previously, in our policies and in a lot of our documentation, we called someone an alleged victim. That person is now called the complainant. Previously, we called someone an alleged perpetrator or alleged harasser. That person is now called the respondent. As I mentioned, the Title IX complaint investigation and resolution process is now called the grievance process. Confusing for those of you who are part of a collective bargaining unit, but those are the terms that the Department of Education chose to use. An educational institution in the new regulations is often referred to as a recipient. That's because they receive funds from the federal government, and that's why they are required to comply with Title IX. What we used to call interim measures that were available during an investigation to both parties are now called supportive measures, and we'll talk about those a little bit towards the end of the presentation. The new regulations amend the definition of sexual harassment. Under the new Title IX regulations, they defined sexual harassment as conduct on the basis of sex that satisfies one or more of the following things. It is employee quid pro quo sexual harassment. It is sexual assault, dating violence, domestic violence, or stalking, as those terms are defined in the Violence Against Women's Act. Or it is the creation of a hostile environment. And the definition of sexual harassment also amends that definition of hostile environment. We'll talk about quid pro quo and hostile environment in a couple slides to follow. When we're talking about sexual assault, dating violence, domestic violence, and stalking, it's important to keep in mind that we are talking about things that are defined in the Violence Against Women Act. You do not need to have criminal charges or at the federal or state level in order for you to report it to your Title IX coordinator. If you receive a report of some sort of forcible or non-forcible sexual offense, criminal sexual conduct, rape, sodomy, some other forcible sexual assault, make sure you report it to your Title IX coordinator, even if all you know about are the allegations, so that your Title IX coordinator can take the appropriate action to start an investigation. Employee quid pro quo sexual harassment is the type of sexual harassment that is most commonly depicted on television. A recipient's employee conditioning an aid, service, or benefit of the recipient on an individual's participation in unwelcome sexual conduct. So what this means is you have an administrator who is conditioning a good evaluation or reassigning someone to a position that they want or a promotion on someone's participation in some sort of unwelcome sexual conduct. In this situation, under these regulations, this is only applicable to an employee who acts as an employee who is the respondent. If a student or volunteer is the respondent, it's not going to be quid pro quo sexual harassment, but it could be hostile environment sexual harassment, or it could be some type of sexual assault. So it doesn't mean that you shouldn't report it. You should still ensure that it gets reported, but it just won't fall under this quid pro quo sexual harassment. For example, if a student council president says to another student, well, I can make sure that you're a homecoming queen if you participate in this unwelcome sexual conduct, that's not going to be quid pro quo sexual harassment because the respondent isn't an employee, but it's probably still going to create a hostile environment for that student complainant. So it should still be reported to your Title IX coordinator as soon as possible. We always emphasize that sexual conduct between a school employee and a student is always prohibited. Consent is irrelevant. Age is irrelevant. The capacity of the student is irrelevant. The age of the staff member or employee is irrelevant. Whether there was a prior existing relationship is irrelevant. It can result in criminal charges. Sexual conduct between a staff member and a student is always prohibited. This applies to volunteers and coaches as well. If you have a staff member who is an assistant basketball coach, who's a recent graduate from your school, and that staff member's significant other is a senior at your school, and they're still engaged in a relationship and likely engaged in sexual conduct, that's going to create a problem for the school under Title IX. The final piece of the definition of sexual harassment under the new regulations is sexual harassment that is created by a hostile environment. Hostile environment sexual harassment is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person's equal access to the school's education program or activity. An education program is any location, event, or circumstance over which the recipient exhibits substantial control over both the respondent and the context in which the harassment occurred. As you can see on this slide, we've emphasized that it has to be severe, pervasive, and objectively offensive, and has to effectively deny a person equal access to someone's education program or activity. We do want you to keep in mind two things, however. One, the reasonable person standard. A reasonable person is not a reasonable person in your circumstances hearing the allegation. It's a reasonable person in the complainant's circumstances. So it could be a reasonable 13-year-old who's walking down the hallway and getting called names every time they pass the lunchroom. Could be a reasonable 45-year-old employee who is being subjected to quid pro quo sexual harassment. We want you to put yourself in the circumstances or the shoes of the complainant when you're considering whether something is so severe, pervasive, and objectively offensive. Additionally, just because you think something might not rise to the level of creation of a hostile environment, it might not be severe, pervasive, and objectively offensive, or maybe it didn't, you're not sure whether it occurred in the school's education program, you still need to report it to your Title IX coordinator and allow them to make that decision. If there is unwelcome conduct that made a staff member or student so uncomfortable that it was reported to you, or you observed it making that person uncomfortable and it was unwelcome and it could rise to the level of sexual harassment, then you need to report it to your Title IX coordinator. Regardless of whether you think it meets these definitions, allow your Title IX coordinator, the investigator, and the decision maker to make that decision and do the appropriate investigation to make that decision. You don't need to try to do it on your own. These are a few examples of things that may rise to the level of sexual violence or the creation of a hostile environment. Verbal sexual harassment can be unwelcome advances or comments, including derogatory, sexually suggestive, or vulgar language. It can also include sexual innuendos. Visual sexual harassment could be subjecting another person to images, text, or cartoons that are sexually suggestive, obscene, or pornographic. It could be students sexting each other via Snapchat or some other social media app. It could be employees sending inappropriate cartoons, photos, or other pictures back and forth to each other. Examples of physical sexual harassment could be the stalking and sexual assault we discussed earlier, but it could also be unwanted kissing, touching, patting, hugging, pinching, grabbing, or other unwanted physical contact, stalking, and sex-based assault or battery. Now we're going to address your new reporting obligations under the new Title IX sexual harassment regulations. How can someone make a report of sexual harassment under these new regulations? The new regulations allow students to report sexual harassment to any school employee, or reports can be sent directly to the Title IX coordinator. Under these new regulations, all pre-K through 12 school employees are considered what's called a responsible school official. That means that if a student makes a report to a bus driver, a paraprofessional, a janitorial staff, that report means the school has notice of sexual harassment and has to take action to address it. So if you receive a report of sexual harassment, you need to ensure that it gets conveyed to the Title IX coordinator so that that person can start taking the steps that are necessary to investigate the allegation and offer supportive measures. These reports can be made by mail, telephone, email, or any means that results in the Title IX coordinator receiving the person's report of sexual harassment. Any report of sexual harassment received by an employee, whether it's something you observe or something you receive from another person, has to be conveyed to the Title IX coordinator. When? Reports can be made any time. Employees have to convey these reports they receive to the Title IX coordinator promptly. This is in red and it's in bold. Similar to your mandatory reporting obligations for child abuse or child neglect, we don't want you to sit on allegations of sexual harassment that you receive and try to decide whether you think something rises to the level of sexual harassment. Report it to your Title IX coordinator and allow them to work through the process and make the appropriate decisions. It's also possible for you as an employee to receive indirect notice. Direct notice is you observing something occurring or someone making a report of sexual harassment to you, but schools can also receive indirect notice of sexual harassment allegations through community forums like OK to Say, through social networking sites. If you follow or are friends with a student on a social networking site and the student posts something on that site that indicates that they have been the victim of sexual assault or sexual harassment, whether it's a Sunday or the middle of summer or a Tuesday at 10 p.m., you need to still report that to your Title IX coordinator. You can also receive indirect notice from the media, something you read about in the newspaper or see on TV, and also sexual violence that is pervasive, widespread, openly practiced, and well known by students and employees. If you are hearing rumors of some sort of sexual conduct occurring between a staff member and a student, for example, and it is so well known, that is something that needs to be reported to your Title IX coordinator. You need to ensure that if it's something that you're hearing about, that it's so pervasive and widespread that it is well known, that that gets reported to the Title IX coordinator to ensure that the school can take appropriate action. As an employee, you have to convey any reports of sexual harassment that you receive promptly. You want to check your specific school policy for the timeline within which you need to convey that report. For example, our True and Law Firm policy requires any school employee who receives a report of sexual harassment or has actual knowledge of sexual harassment to convey that information to the Title IX coordinator by the end of the next business day. What we are emphasizing here is if you see something, say something. If you observe sexual harassment, if it's reported to you, if you're aware of it because of social media or because it's so widespread or pervasive, say something. Report it to your Title IX coordinator. Don't try to hope it will just go away or try to handle it on your own. Non-compliance with these reporting requirements can lead to discipline. Deliberate indifference is the legal standard for how courts determine whether a school has violated Title IX. Schools cannot be deliberately indifferent to allegations of sexual harassment. What that means is the school cannot fail to respond reasonably in light of known circumstances. So the school has to respond to allegations of sexual harassment in a reasonably prompt time frame. This means we need to take all complaints of sexual harassment seriously. Staff to staff sexual harassment, staff to student sexual harassment, student to staff sexual harassment, and student to student sexual harassment. We need to take all of them seriously. Behavior that may be sexual harassment must be reported. We cannot hope that it's just going to go away or resolve on its own. To give you an idea of the various ways in which a school could potentially be deliberately indifferent, we provided this grievance process roadmap. Again, the grievance process under the new Title IX regulations is the process from the formal complaint through the determination of responsibility and through the appeal. As you can see, number 1 with a bullet is the report of sexual harassment. Your role in this process is integral. As employees, you are the school's eyes and ears. The Title IX coordinator cannot be everywhere in the school at once. It's your responsibility, if you receive a report of sexual harassment or observe sexual harassment occurring, to report that to the Title IX coordinator so that they can ensure that steps 2 through 5 are taken and that the school is not deliberately indifferent. After that report of sexual harassment is conveyed to the Title IX coordinator, the Title IX coordinator then will sit with the complainant, determine whether they want to file a formal complaint, which is a written document signed by the complainant, or it can be signed by the Title IX coordinator. Then the investigation process is going to begin, or an informal resolution process may begin. Throughout that whole process, the respondent is presumed not responsible. In the investigation process, at the end, both parties are going to have an opportunity to review any evidence before the investigation report is finalized. Then the process goes to the decision maker. That person is in charge of making a determination of responsibility, deciding whether there was a violation of the Title IX policy or not. That person is also responsible for issuing any discipline or any sanctions and for determining what appropriate remedies there are for the complainant or the respondent. And under the new grievance process, all parties are entitled to appeal if there is a conflict of interest or bias that could have affected the outcome of the case, if there is new evidence that could have affected the outcome of the case, or if there was some other procedural issue that could have affected the outcome of the case. As we've been talking about, there are 4 key roles under the new Title IX regulations. There's the person who serves as the Title IX coordinator. That person oversees the investigation and coordinates the school's compliance with Title IX. That person is likely to help with the formal complaint being filed and with implementation of supportive measures. Then there's the investigator. That person conducts the investigation process, interviews people, reviews evidence, and puts together the investigation report. Next is the decision maker, who makes a determination of responsibility after reviewing the investigation report and any response by the parties. Then there's an appeals officer who hears the appeals of any case that was dismissed by the coordinator or investigator, and also hears appeals of any determination of responsibility that was issued by the decision maker. The investigator, decision maker, and appeals officer must all be different people, and they must all have no conflict of interest or bias. Again, if you are asked to serve in one of these 4 roles, please ensure that you receive comprehensive training on the new regulations, on the grievance process, because the new Title IX regulations require specific training for people to serve in one of those 4 specific key roles. Another key role in the process is an advisor. The new regulations allow both parties to have this, they're not required to, but they may have an advisor of their choice to assist them during the grievance process. The school cannot restrict who serves as an advisor, but if, for example, a student or other staff member requests that you serve as their advisor, you are permitted to refuse that request. Advisors are going to accompany a party to any interviews that they are a part of during the investigation, accompany them to any meetings. In the informal resolution process, they may accompany them to those meetings or to other meetings to review evidence. They're going to discuss potential relevant evidence and witnesses with the party that they could present to the investigator. They're going to review evidence and the investigation report and help the party prepare their responses. And that advisor should be familiar with the school's Title IX policy and with the school's new Title IX procedures, with that grievance process we just described. Finally, we're going to touch on supportive measures. Supportive measures are important for all of you to know about because while the Title IX coordinator and the decision maker are the ones who are in charge of creating and implementing these, it's really going to be all of you who are at the school building level who are assisting the school with implementing these supportive measures. Supportive measures are available before, during, and after an investigation, and they're available even if the complainant decides not to file a formal complaint. The Title IX coordinator is going to oversee implementation of these, but again, that implementation is likely going to require the participation of several employees and staff members like you. Supportive measures under the new regulations have to be non-disciplinary, they cannot be punitive, they have to be individualized, and they are designed to restore or preserve equal access to an education program or activity without unreasonably burdening the other party. Some examples of supportive measures are offering the student or staff member counseling, making changes to a student or staff member, whether they're the complainant or the respondent, making changes to their work or class schedule, increasing monitoring in hallways or in between class changing periods. Supportive measures cannot include anything that completely removes a respondent from an activity, except under very limited circumstances. Under the new regulations, staff can be removed during an investigation and put on paid, non-disciplinary administrative leave, and students can go through what's called an emergency removal process that will be run by the Title IX coordinator and investigator. But generally, we're not going to be removing respondents from activities under these new regulations. A requirement of the supportive measures is that the school has to document whether supportive measures were offered and which supportive measures were taken. These supportive measures are going to be kept confidential to all extent possible while still complying with the Title IX requirements. So if you're asked to assist with the implementation of supportive measures, you may be asked to assist with monitoring in the hallways. You may be asked to help change class schedules or lockers or lunch schedules around. You may be asked to ensure that two students sit far apart from each other on the bus. You may be asked to help ensure that a no contact order is followed when students are passing each other in the hallway. All of these things are possibilities, and you may be asked by the Title IX coordinator to help document whether those supportive measures were actually being taken and being followed on certain days at certain times. Additionally, if you're asked to help implement supportive measures and you see that they're not being followed, or for some reason they're not being implemented, let your Title IX coordinator know. If that locker hasn't been moved yet, if the increased monitoring, someone isn't showing up to help do the increased monitoring, because a school can be held liable for simply saying they're going to do something and then not actually implementing it. Retaliation. Retaliation is prohibited. It includes threats, intimidation, and coercion against a person who makes a report, files a formal complaint, participates in or refuses to participate in a Title IX proceeding. This is one of those areas where you as an employee, if you convey a report of sexual harassment to the Title IX coordinator, you are protected from retaliation. If you make that report about a supervisor, for example, and that supervisor tries to give you a bad evaluation, demote you, or reassign you in response to the fact that you filed this complaint against them, that could potentially be retaliation, and you are protected from that under these new regulations. It's important to note that under the new regulations, someone exercising their First Amendment rights does not constitute retaliation under these new regulations. What that means is certain things like bullying or offensive language aren't necessarily going to rise to the level of retaliation. But again, threats, intimidation, and coercion, asking someone why they lied, asking someone why they told on someone, asking someone why they're trying to ruin someone's life, calling someone names because they made a report, all of those things could potentially rise to the level of retaliation. One other note here is that under the new regulations, charging someone with what's called collateral misconduct may rise to the level of retaliation. For example, if a school attempts to charge a student complainant with underage drinking in order to discourage that complainant from reporting sexual harassment or participating in an investigation, that could potentially be retaliation. So if you had a student complainant who made a report and a formal complaint against a football player, and in order to ensure that that football player could play in an upcoming game, the school said, well, we're going to charge you with underage drinking unless you withdraw your report of sexual harassment, that could potentially be considered retaliation. But it would have to be a charge that was intended to discourage the complainant from reporting sexual harassment or from participating in the investigation. We want to talk about protecting student privacy. You're all very familiar, I imagine, with the Family Education Rights and Privacy Act, or FERPA, and some of our state laws that we have in Michigan that protect student privacy. So one of our most important responsibilities is keeping student personally identifiable information confidential. Schools have to keep confidential the identity of a person who reports sexual harassment or files a formal complaint. This includes the names of parties and includes the names of witnesses. And as I mentioned before, supportive measures must also be kept confidential. The only exception to this is that though that information is not kept confidential, as it is required or permitted by law to carry out any provisions of Title IX. As I mentioned before, under the new regulations in the investigation process, the parties are permitted to review any evidence and provide a response. They're then, in the decision-making process, allowed to review the investigation report and provide a response and ask questions. In those situations, the identity of the complainant and respondent are going to be provided. But if you are involved in a Title IX investigation, you need to keep in mind that outside of that investigation process, talking to other staff members about the investigation, providing student personally identifiable information to law enforcement without talking to your Title IX coordinator and school administrators first, you're responsible to keep confidential the information that you might receive as part of a Title IX investigation until or unless someone tells you that you can release or disclose it. We wanted to touch here at the end of the presentation on a few dangerous mindsets. These are terms that we have heard from clients in investigations that we have handled. We don't want any of you to say these things out loud, but even if you're not saying these things out loud, we also don't want you to have this attitude towards allegations of sexual harassment. For those of us here in Michigan, we're aware that Title IX is a very big deal because of the Larry Nassar case at Michigan State University. But Title IX sexual harassment is a very big deal at the K through 12 area as well. As we demonstrated with the settlements at the beginning, schools can be sued and OCR, the Office for Civil Rights, can come in and investigate for these allegations of sexual harassment. Not only are we concerned about liability, we want to create a safe learning environment for all students. We don't want any of you to be saying, if you see or hear about sexual harassment, that it's just a joke or it's just teasing. That person just needs to lighten up. It's just a prank that got out of hand. When you are thinking about allegations of sexual harassment or you observe something that you think might be sexual harassment, don't use yourself as the reasonable person. You're an adult. Use the student as a reasonable person. Place yourself in their circumstances. Don't want you thinking that the way a student dressed, that the way a student acted, it's a matter of student hormones, because the student's disciplinary history or the grades the student gets or the student's eligibility. We don't want you thinking any of those things make them more or less susceptible to sexual harassment or more or less believable if they make allegations of sexual harassment. We also don't want you to be making decisions simply on a matter of, well, boys will be boys or girls will be girls. And finally, we don't want anyone to be forced to accept verbal or visual harassment simply as, well, why can't you accept a compliment? If you didn't dress that way, no one would say those things to you. Or the suggestion, maybe you should transfer to another school because you just can't handle it here. Transferring to another school could create a lot of liability for the school district. Bringing it all together here at the end. These new Title IX regulations create a new mandatory reporting obligation for all school employees. If you see, hear, or otherwise find out about an allegation of sexual harassment, convey it to the Title IX coordinator as soon as possible. Remember, the district is required to respond to these allegations promptly within a reasonable time frame. Holding on to an allegation to try to decide whether you should report it or not is really going to cut into the district's ability to respond to allegations. Leave it to the Title IX coordinator to assess the allegation and determine what next steps are necessary. Don't try to do it on your own. You are protected from retaliation for reporting these allegations of sexual harassment. And keep in mind that failing to report allegations of sexual harassment will result in discipline up to and including termination. Thank you for tuning in for this training today. We hope you have a great rest of your day.